Okay, let's go ahead and get at it. Welcome to class. We're going to cover international law tonight, which is my favorite subject in the entire course because this is what I do when I'm not playing dean or doing something else administratively. This is actually my area of research, and more specifically the European Union. So go ahead and skip to your international law outline, and we will go ahead and get at it. Okay, now, first things first, there are a lot of people that would say there is no international law. And for years and years and years, I go to conferences and they say, oh, there's no such thing as international law. There couldn't be, because there's no international police force. So how in the world can you possibly say there's international law when there's no group to enforce it? And I disagree. International law has been around for thousands and thousands of years. Whether it be governments, groups of people, what have you, they've always had arrangements, they've had contracts, they've had treaties, what have you, to find some kind of way to coexist. It could be trade in goods, it could be just government relations, politics, etc. But nonetheless, this body of law has been around a long period of time. So it's often the more conservative folks that do this for a living that say, there's no way there's any international law. However, that's not to say there aren't some enforcement problems. Generally, international law is best enforced with groups of countries. All right? And some of this is kind of a sociology as well as a military might level, if you will, M-I-G-H-T. In the sense that if you have a lot of countries that band together and point to the country that's not doing what that particular country should do or doing something egregious, all right, those countries can kind of get together, point to that country, and then perhaps use their unified might to enforce the law. So let's talk about how international law can be enforced. Well, the oldest way, of course, is simply through war, right? Through military force. A country or a group of countries simply attacks the one country that is acting out of an accord with international law. Second, and what we use more so today, are economic and trade sanctions, which in the long term generally work. All right, it might take some time, it may take a long time, it may take months, it may take years, but the research is pretty clear. Economic and trade sanctions tend to work very well. Does it take some time to get some compliance from that transgressing country? Absolutely, but nonetheless, it tends to work quite well. Okay, two things we often don't think about. So third on our list would be the severance of diplomatic ties. Now we've seen this kind of a lot recently with the United States government and the Russian government pulling their diplomatic corps, and in one particular case, of course, kicking out diplomatic corps. But nonetheless, there can be some very debilitating realities with that. When you're kicking out the diplomatic corps, chances are there's very little communication. Not a whole lot can get done after that. And then lastly, sometimes we forget boycotts. Countries can certainly boycott the activities of another country. Now, I'm 48 years old now, soon to be 49 next month, but when I was growing up, there were two very significant Olympic boycotts. In 1980, the United States did not go to the Moscow Olympics, and held in the Soviet Union as it was then. And in 1984, the Soviet Union did not send their Olympic team to the Los Angeles Games. And there was kind of a debilitating effect. I mean, those were two very, very good athletic teams. But nonetheless, the symbolism was certainly there. Okay, let's talk next about the nature of international law. The best way to look at international law is that it is a system in and of itself. So if you remember from way back when, on the first page of the outline, and we were looking at different legal systems. We looked at common law, we looked at civil law, we looked at socialist law. We could have very easily added international law. International law has its own tort law, its own criminal law, its own contract law. A lot of this we're going to go through today. All right, its own administrative law. But if I were to put it into any one of those particular categories, right, the 6 that we had on the first page of this, the outline for this particular course, I would say is much more tuned to civil law. Okay, now if you go back, remember, civil law does not have precedent. So sometimes it gets tricky. So a guy like me who researches international law for a living, you're kind of depending upon precedent and like cases being treated in like manner, and that doesn't necessarily happen. So sometimes it's very, very frustrating. Okay, now a couple of things, however, before we go any further and actually get into the sources of international law. If we're talking about international law, we have to have 2 or more countries. So if we're talking about conflict within one particular country, it isn't really international law that's in question. Okay. Now, if you think about what's going on in Spain right now, the disagreement between the Spanish national government and the Catalonian government, that kind of a conflict isn't really international law. Now, the Catalonians might say we're a separate ethnic group, we should be entitled to some level of sovereignty. That's not really international law. So you absolutely have to have 2 different nations having some type of dispute. Okay, now if that's said, let's go ahead and look at these various sources of international law. And these are the things I like to point to when there are persons saying, well, there is no international law. So, Tudor, you're crazy. There's no way international law exists because there isn't any international police force. Well, again, as I had said, I disagree considerably. Okay, now we're also ranking the sources of international law. So as we go through this is a rank order. So I very well may ask you a question on the exam whether treaties trump customary law. Okay, so go ahead and take special note to the ranking as we go through them. Okay, so let's start at the very top, and this is with treaties and international agreements, right? Treaties and international agreements. Now, treaties are contracts. Very, very simple in that respect, right? Do they take months, maybe years to negotiate? Absolutely. I'm not saying the terms might not be complicated, but treaties are merely contracts between 2 or more countries. Okay? Now, one thing I want to note is the treaty making system in the United States. All right? 2 parts. Number 1, the president has to sign the agreement. Number 2, the treaty has to be ratified by a 2/3 majority in the United States Senate. Now, notice, by the way, the House of Representatives plays no role in the treaty-making process. Now, they can complain, jump up and down, what have you, okay, but they do not play a role in the treaty-making process. Okay, now, in our legal system as well, there is a difference between a treaty and an international agreement. I want to point that out to you. With a treaty, president signs it, 2/3 vote in the Senate, right? An international agreement merely would require the president's signature. So actually in our legal system, the American legal system, there is a slight difference, right? So a treaty would outrank an international agreement. Now, outside the United States, that's really not the case. Every country has its own treaty-making process, and it's not for us to judge. Could it be the president or the chancellor or the prime minister or the monarch, perhaps, that merely signs the agreement and it's a treaty of that country? Very well could be the case. Could it be a very undemocratic process? Absolutely, but again, it's not for us to judge. Okay, however, let's go ahead and put them back together since we're talking about international law and look at the various types of treaties. Now, a lot of this deals with membership and essentially permission to join. So if you look at bilateral treaties, real simple, 2 countries. Right? 2 countries that get together and agree to like terms. So if you remember all that contract law we've been covering, it's really no different than that, right? These 2 countries agree to like terms, you have an agreement. These countries, of course, do have to have some genuineness of assent, right? They agree as to what these terms mean, but generally not a problem. Much easier to negotiate a bilateral treaty than the 2 types of multilateral treaties. Okay, now if you look at your outline, there are 2 types of multilateral treaties. The first type is a multilateral restrictive, okay? 3 or more countries, right? It's multilateral, but it's invitation only. So that means the existing treaty parties, right? Treaty nations have to invite you in if you want to be a member of that treaty organization, okay? You have to be invited. The classic example, right, and of course my area of research, is the European Union, right? It's a group of 28 countries, and you have to be invited, right? There are many countries in Europe that would like to have that invitation. They haven't quite gotten it yet. And of course, right at the time of this presentation, there's one country that's trying to get out of it. And again, we'll talk more about the European Union when we get there. But again, invitation only. Most trade agreements look like that, all right? Most trade treaties look like that. It's invitation only. And there is some social distance concerns that you're going to find. Most multilateral restrictive treaties are geographically tight, right? The European Union, guess what? You got to be part of Europe, right? Now, might you disagree as to what's part of Europe? Sure, that's absolutely possible. Okay, let's look at multilateral general treaties. 3 or more, but open invitation. So those existing treaty members, right, those countries are saying, hey, other countries, if you're willing to meet these terms, you're welcome. And the classic example would be virtually every United Nations convention. All right, is a treaty, and they are open invitation. If you're willing to meet these terms and conditions, you are welcome to come in, okay? And I happen to be one of those supporters of the United Nations. I think it's done a fantastic job. Has it been perfect? Absolutely not, but it has done what it was supposed to do, and that's keep us out of World War III, okay? But again, by being open, for those of you that have taken a good history class, you may have studied the League of Nations. The League of Nations failed largely because it wasn't open invitation, right? And of course we wound up in World War II. Okay, so with that said, you look at all these treaties and these international agreements, right? That's the top tier of international law. So let's look at international customs, okay? Now, this is the second ranking source of international law, and it's probably in some cases the toughest, I should say in many cases, not some cases, in many cases the toughest to decipher. Because what we're looking at here are long-standing rules that countries have merely adhered to. So thousands of years, hundreds of years, right? There are some things that countries just say, you know what, these are the rules. We followed them this long, we're going to keep following them, okay? Many of these are trade rules, and many of them, of course, are rules just dealing with government relations, political relations, etc., okay? Now, having said that, there is a test for an international custom. A custom would be considered international law if a majority of the world's countries agree to follow it. Now, there are some questions. Well, how many countries are there in the world? All right, there are differences of opinion, right? You're going to get a guess is somewhere between 190 and 200 countries. You could use 195 if you wish, but there are questions, there are doubts. Countries have to be recognized by other countries. So think about Kosovo, all right? Didn't have a whole lot of support, but now, for the most part, majority of the world's countries believe that Kosovo is a separate country. Bosnia-Herzegovina, again, it can go on and on. Quebec would like to be independent, perhaps. It just never got the recognition. And I think that's actually a good thing. Okay, now if you look at your outline, you see that there's something called a regional custom. Regional customs tend to be geographic specific and often continent specific. All right, so you think about a group of countries that are bordering upon each other and located on the same continent. And there are two continents that are very noteworthy for having regional customs that might be different from international customs. Okay, two continents, you find this a lot on the Asian continent, you find a lot of this on the African continent. I could make a smaller argument for South America, but I'm only going to hold you to Africa, the African continent, and the Asian continent. Okay, now, you might think, well, what's the big whoop? Here's the big whoop. If the regional custom and the international custom conflict, what happens? Well, the answer depends on what countries are involved. So let's say, for instance, we have a buyer and a seller. Buyer's in Seattle, Washington. Seller is in Beijing, China. All right? Well, then the international custom is going to be what prevails, right? Because you're not within the same geographic region, you're on two different continents. And admittedly, that's kind of an easy example, but we're going to go ahead and use it. Okay, now, what about a contract between buyer and seller? Seller is in Tokyo, buyer is in Beijing. Well, the regional custom is going to prevail, right? So if you get conflicts between a regional custom and an international custom, you really have to look to see what countries are involved and where those two parties are located. Okay? All right, now let's look at international organizations and conferences. Now, international organizations are groups of countries, and they tend to be permanent. That's what separates them from an international conference, right? So international organizations such as the European Union and the United Nations, they create more law, right? So there's a treaty that creates them in the first place, and then there are these organizations created by those treaties that create more law, right? So in the case of the European Union, directives, decisions, regulations, right? More law from that organization that was created by the treaty. Okay, same thing with the United Nations. All right, and United Nations are, if you probably heard this, the United Nations is constantly making resolutions, right? Well, that's part of their body of law. Okay, however, to separate the international organization from the international conference, the conferences are temporary and they want to handle one specific thing, all right? The classic, and by the way, your book does a good job of explaining this, and it's the Convention on Contracts for the International Sale of Goods, CCISG, all right? Classic example, a group of countries, late 70s, get together, and by 1980 they had finalized it, and they said, these are going to be the rules on contracts for the international sale of goods. Temporary, they just got together, wrote the document, the convention itself, and then said, that's it, okay, we're done. All right, but notice they hold a rank of third on our list. Okay, and lastly, general principles of international law. Now, admittedly, these can be as tough in many cases as international customs to decipher, but what you're looking for is a common thread through the various legal systems. Okay, so if you go back to that first page, right, of our outline for the course, right, common law, civil law, socialist law, Islamic law, Talmudic law, customary law, murder, homicide, violates the criminal law in every one of those legal systems. So you can certainly make the argument that a general principle of international law is homicide, right? Now, the punishments may be very different, right? The punishments may be very, very different. If you didn't know this, the United States, for example, is the only Western democracy that has the death penalty. Only one, okay? And again, that has caused us some problems when we're trying to have criminals move from one country to the next. Okay, so source of international law, you now have a ranked system. Okay, now let's go ahead and look at sources of jurisdiction. Now, what we're looking at here is really the power of a particular court in a country to hear a case, right? And this is true. Anytime you see that term or read that term or hear that term, jurisdiction, you're thinking about power, right? The ability to hear a case, have control over that case. Now, if you look at your outline, now, by the way, this is not in the book, but I find this to be some of the most important points in international law, okay? What gives a country the power to hear a particular dispute? Okay, so what we're going to do is we're going to start with the territorial principle. This is also the easiest principle, right? A country has jurisdiction over every act that takes place within its international borders, right? So if you think about the United States, right, just a little bit of artwork here. Let's see if I can do this. You may actually find this amusing, so. All right, that's United States. That'll make you laugh, won't it? Okay, but nonetheless, all right, these are the international boundaries, right? The continental United States, yes, I do know Alaska's here and Hawaii's out here. Okay, but nonetheless, if it takes place here, American courts have jurisdiction over that case. And it doesn't matter who's involved. Could be foreign people, foreign companies. It doesn't matter. If it takes place here in the United States or Guam or Puerto Rico, U.S. Virgin Islands, doesn't matter. The United States courts have jurisdiction. All right, probably the easiest. And if you think about it, it makes sense, right? If it takes place here, the United States is going to have an interest in determining the outcome, perhaps holding people accountable, either civilly or criminally, right? Very, very important. Okay, now let's go ahead and look at the second principle, all right? The nationality principle. A country has jurisdiction over its citizens wherever they go in whatever they do, all right? So think about that. The United States, right, has jurisdiction over Americans wherever they go in whatever it is that they do. Right? I'm an American citizen. We'll talk about why I'm an American citizen here in a minute. All right? Wherever I go, if I go to Belgium, if I go to Thailand, if I go to Australia, it doesn't matter. American courts have jurisdiction over whatever involves me. Right? Now, very important because we're going to separate the nationality principle from the passive personality principle. The nationality principle concerns citizens as wrongdoers. All right? Involves citizens as wrongdoers. So, if I go to Australia and do something to an Australian, if I go to Belgium and do something to a Belgian, all right? I can be held accountable in an American court. Okay? Even though the act took place in Belgium, took place in Australia, Thailand, whatever it is, I'm the wrongdoer. Okay? Now, for citizenship, all right, we have to talk about, under international law, what makes me an American citizen. Okay? Well, me specifically, I was born in the United States, right? So, if you are born in that country, you are a citizen of that country. Right? Doesn't matter where your parents are from, right? The very fact that you're born here in the United States makes you an American citizen. Now, let's say, however, I was born in Germany, right? But my parents were American. That makes me an American. It also makes me a German. Okay? Now, one of the things you have to keep in mind in the modern age, it is very easy to have dual citizenship. Now, if I were teaching this class 60, 70 years ago, I would say just the opposite. It was very, very difficult to have dual citizenship. Now, it's very, very easy. Okay? Now, let's say I was born in Germany. My father's American. My mother is Swedish. Yeah, I might have 3 sources of nationality. Okay? So, international law is much more flexible than I think a lot of people think on the point of citizenship. Okay? Regardless, right? Let's say I'm born in Germany, I have an American father, my mother is Swedish, right? And I do something in Australia. Well, you've got 3 countries that can exercise jurisdiction based on the nationality principle. Okay? So again, sometimes much more complicated than you would think. Okay, now the passive personality principle, all right, looks much like the nationality principle, but instead of citizen as wrongdoer, it's citizen as victim. So under the passive personality principle, a country has jurisdiction over its citizens wherever they go, whenever they are victimized. So if I go to Australia and I'm victimized, I'm hurt, right? The American courts still have jurisdiction, right, over that particular matter. So let's tie this together with an example. Let's say I go to Montreal, Canada. I'm an American citizen. And I take a brick and I throw it at a Belgian citizen. All right? I'm American. I go to Montreal, Canada. I take a brick and I throw it at a Belgian citizen, hurting him or her. terribly, all right? Blood streaming down, you get the idea. Okay, now, 3 countries have jurisdiction, right? The United States has jurisdiction based on the nationality principle, I a citizen wrongdoer. Belgium has jurisdiction under the passive personality principle, right? Citizen as victim. And Canada has jurisdiction based on the territorial principle. Okay? Now you might say, well, where is this case going to be heard? Well, we'll deal with that later, all right? There is an efficiency concern, all right? But the one thing I want to leave you with as we exit that example is that I could be prosecuted in 3 different places, all right? And I might be prosecuted in 3 different countries. Okay? There is no double jeopardy protection under international law. None. All right? Now, if I were tried in Canada and convicted, chances are the United States courts and the Belgian courts aren't going to care. I mean, they're probably not going to take it up because it just wouldn't make any sense. I've already been punished, etc. Okay? But if the penalties are grossly different or the law is grossly different, those countries may have an interest in prosecuting. Now, by the way, it could be the same thing between buyers and sellers, right? Could be an American buyer, a Belgian seller, and the activity, right, the contractual activity is taking place in Canada. So it could be a civil case. It doesn't matter. You would certainly look at the efficiency, past jurisdiction, right, and you look at any differences in the law for sure. Okay, now those 3 are actually pretty easy, I think, okay? These next 3, right, you got a list of 6, these next 3 get a little bit more complicated. So let's look at the protective principle. Now the protective principle allows a country to exercise jurisdiction over a matter that could affect its internal security, could be military security, economic security, but the activity is taking place somewhere else, right? So the act could affect security, military, right, physical security, if you will, economic security, but the activity is taking place somewhere else, okay? So imagine a plot between 2 companies, right? Let's say it's an Austrian company and a Romanian company, right? And they're plotting in Switzerland, but they're plotting to fix prices, right, in the United States. Okay? If you put all that together, you're actually going to find 4 countries that have jurisdiction, right? 4 countries that have jurisdiction. Okay? So, if you think about the countries that have jurisdiction, right? Austria, Romania, right? Switzerland, and the United States. Now, often the protective principle is seen as controversial. Countries might abuse it, saying, well, that's really going to hurt our security, military, again, physical or economic otherwise, and maybe they try to abuse that a little bit. But nonetheless, for the most part, countries adhere to it quite well. Okay, now, notice, however, the protective principle is country-specific. So the United States, if exercising jurisdiction over that price-fixing case that's taking place, the activity is taking place in Switzerland, but it's an Austrian company and a Romanian company plotting to do that, it is affecting the United States. This is different, however, than the universality principle, okay? Now, the universality principle has a mission, and that is to make sure that people who engage in such egregious acts are prosecuted, that they're punished, right? Could be criminally or civilly for sure, all right? But there's this belief that there's some acts that are so heinous, so bad, so evil, right, that every country has jurisdiction. Doesn't matter whether it affects that particular country or not, whether it involves their citizens, their territory, their economic security, their physical security, military security, doesn't matter, okay? I'm going to give you a short list, okay? Any act of slavery can be punished by any country, All right? Now, human trafficking is probably a classic example of that, unfortunately, and I mean that seriously. Okay, next. Aircraft hijacking can be punished in any country. Doesn't have to involve its citizens, its territory, whatever. There is no safe haven, right? Third, genocide, right? The intentional destruction of a particular group based on nationality or ethnicity or race. That can be punished anywhere, okay? All right, torture. Torture can be punished everywhere, right? Now, admittedly, there's often a debate about what is and what is not torture. We've seen some cases that deal with just really brutal employment conditions, and many courts have made the argument that's torture. It really depends on the facts, okay? Now, the last two are pretty important, right, on our list. War crimes. War crimes can be prosecuted criminally or civilly in any country, and it doesn't matter who's involved, what countries are involved, etc. Okay? All right. Lastly, piracy. Now, piracy, you know, if you've watched a lot of old movies, you're probably thinking of Bluebeard or Blackbeard with an eye patch and, you know, a parrot on the shoulder or whatever. Okay, but there is a lot of piracy going on in this world today. It affects shipping lanes, okay? And there are two areas of the globe where this is a real problem. One is the eastern coast of the African continent. And you remember a couple of years ago, there were some infamous cases dealing with that. But this has been going on for a long, long period of time. They just were noteworthy. Same thing in the Southeast Asian seas. You see a lot of piracy. Now again, certainly it takes place, but the best way to know that it takes place, try to insure goods moving in and out of Southeast Asian waters. It is prohibitively expensive. Pirates still exist. They will stop you, loot you, shoot you, and then sink you. Okay. Now, on the Eastern African coast, admittedly, they're generally geared on kidnapping, ransom, that type of thing. And of course, you can kidnap people as well as cargo. So really doesn't matter, I guess, in that respect. It's expensive. Anytime you're trying to insure goods coming in and out of those waters, it's very, very pricey because of that concern. But again, the idea is there are so many again, the list is much longer than this. There's so many activities that are just so heinous, so bad, so egregious. Every country can have jurisdiction. Okay, and then lastly, jurisdiction by agreement. Now, often we think of treaties that can establish jurisdiction. That's certainly true. But it can be something as simple as a lease agreement. Very, very easy, right? Classic example, military bases, American military bases around the world, right? A lot of people kind of think, well, when you're on a military base, you're on American soil. You're not. You're in Japan or you're in Germany, etc. But there's generally a lease agreement whereby jurisdiction is established. So when it comes to any problems with American service personnel overseas, jurisdiction has to be worked out. Now it can be held with the country holding the lease, or it could be maintained rather with the country that holds the lease, or it could be the country wherein the Air Force base, Naval base, Army base is contained. So if you think about Japan, we have an Army base in Japan, Naval base